Thank you, Kathy, and it's great to be back with all of you. It is our last broadcast for the month of October. So glad that we had what was really terrific turnout last week for our special webinar on the Clean Slate Act. With any luck, it was informative to all of you who joined, and I know based on the volume of questions that we received that a lot of you are trying to sort out how to plan ahead. So we certainly believe that it was useful information, and it's our plan to have more special programs that focus on specific topics on a going forward basis. So look for that. Nothing to announce specifically today. We'll have our traditional format today, but just keep in mind that, based on the kind of feedback that we got and the nature of value that it provided to you, we'll be doing more of that. But for now, let's go to the agenda, please, Kathy, and walk through all that we have on tap for today's program, which I think is plenty informative and will be worth your time. So after I'm done here, we'll shift to Natalie Vogel, who's up in Albany. I'm, of course, here in New York City, I should note, where there is a Halloween feel around and people are getting ready, certainly my kids, among others. Up in Albany, I'm presuming much is the same, and Natalie will be back on the program to discuss the NLRB General Counsel's issuance of a memorandum concerning non-compete agreements. That has been an ongoing topic of discussion, non-compete specifically here on the webinar, and we want to keep you all up to date. There was a recent information memo that went out on the topic, and this will build off of that. I'll be presenting after Natalie to talk about some issues at the intersection of healthcare and cybersecurity. First, I'll be talking about standards relating to federal funding, and then I'll be focusing on hospital cybersecurity standards here in New York State. Alyssa Christian is back, and we're delighted to have her from Syracuse. And she looks forward to discussing the FTC announcement concerning click to cancel final rules. And then we'll have a new presenter as our last for the afternoon, who's Paige Rosenman. She's with us from our Buffalo office, and she'll be looking at GPS tracking in unionized and non-unionized workplaces, a really interesting topic and one that we haven't brought to this group's attention in some time. So Paige, we're glad to have you on for that, and we look forward to introducing you more formally later in the program. I will wrap things up with any luck around 12:45 Eastern, and I will, of course, throughout take your questions as you have them. But for now, why don't we move to Natalie, who I am delighted to introduce. Natalie is with us, as I mentioned, from Albany, where she is an associate who focuses on labor and employment. And she also has a background in litigation. She has worked in personal injury, medical malpractice. And with that background in labor law, she was well suited to prepare this memorandum on what the NLRB's General Counsel has to say on this emerging topic. So with that, I'm delighted, Natalie, that you're back with us, and please go ahead and catch us all up. Thank you very much for your time.
Yeah, thank you, Gabe. Happy to be here. So as Gabe informed you all, I will be discussing the recent NLRB General Counsel memo. So Kathy, if you could go to the next slide, please. So on October 7, 2024, the NLRB General Counsel, Jennifer Abruzzo, issued a memorandum regarding non-compete agreements and stay or pay provisions as they relate to the National Labor Relations Act. It discusses those two topics, and I just wanted to note right in the beginning that as we go through my presentation in the next slides, the memo by the NLRB General Counsel does not represent current law. Rather, it serves as guidance for the NLRB and regional offices to consider when analyzing whether an employer violated the NLRA. So as you may be aware, last May, General Counsel Abruzzo issued a memo advancing the position that non-compete agreements between employers and employees that limit employees from accepting certain jobs at the end of their employment interfere with an employee's rights under Section 7 of the NLRA. So when she issued the second memo in October, she kind of expanded on that position and addressed potential penalties for unlawful non-competes. So she stated, in addition to rescission of the agreement, the employee may be eligible for make-whole remedies. The memo suggests that employees may obtain make-whole relief through, one, demonstrating that they were deprived a better job opportunity because of non-compete provisions. I'll touch on that in a little bit. And then they also state that employees may be entitled to relief for additional harms or costs associated with complying with the non-compete during the post-employment period. So, for example, if an employee had to move outside of a geographic region to obtain employment in order to comply with the non-compete, the employer may be ordered to compensate the employee for moving related costs. Next slide, Kathy. So how can employees show that they were deprived a better employment opportunity? They'll have to meet this three-part test, which is that they have to show there was a vacancy for an available job for a better compensation package. 2, they were qualified for the job. And 3, they were discouraged from applying or accepting the job because of their non-compete provision. And then if an employee makes this showing, then the employer must compensate the employee for the difference in pay and benefits between what they would have received and what they did receive during the same period. So based on the specific employment industry or geographic locations, this could, get up to a substantial cost for this make-whole remedy. Next slide, Kathy. So the second part of the general counsel memo, and I'd say the bulk of the memo, addresses stay or pay provisions, and specifically the general counsel puts forth the position that stay or pay provisions are presumptively unlawful under the NLRA. So what is a stay or pay provision? The memo defines it as any contract under which an employee must pay their employer if they separate from employment, whether voluntarily or involuntarily, within a certain time frame. So stay or pay provisions in practice are typically tied to training repayment agreements, educational repayment agreements, retention bonuses, sign-on bonuses, relocation bonuses. A simple example of a stay or pay provision is that if the employee separates from employment within a 2-year period for any reason, they'll have to pay the employer back for the $10,000 relocation bonus provided to the employee. So that's just a general example of what a stay or pay provision entails. Next slide, Kathy. Thank you. So luckily, the memo provides an opportunity for the employer to rebut the presumption that the stay or pay provision is unlawful. So to do so, the employer must provide that the provision advances a legitimate business interest and is narrowly tailored to minimize infringement on Section 7 rights. So an employer may meet this burden by showing the stay or pay provision is, 1, voluntarily entered into in exchange for a benefit, and as the memo describes, to be entered into voluntarily, employees must be permitted to freely choose whether or not to enter into the agreement. So if they do not sign the agreement, they can't suffer any financial loss or an adverse employment action. And if they do, then it wasn't entered into voluntarily. 2, there has to be a reasonable and specific repayment amount. 3, the provision has to have a reasonable stay period. And 4, the provision cannot require repayment if the employee is terminated without cause. Next slide, please, Kathy. So similar to non-competes, the memo also addresses penalties for unlawful stay or pay provisions. So there's 2 categories that the general counsel divvied up stay or pay provisions. So she divvied them up into voluntarily entered agreements and non-voluntarily entered into agreements. So if the provision was entered into voluntarily, but may not be narrowly tailored in one or more of the ways I described on the previous slide, then the employer should rescind the unlawful provision and replace it with a lawful one. If the agreement was not voluntarily entered into, then the general counsel will seek an order canceling the debt. The employee has the opportunity to show they were deprived a better employment opportunity with the same standard as the non-compete that I discussed earlier. And then if an employer attempted to enforce the unlawful stay or pay provision, additional remedies such as legal fees or compensation for damage to credit may be ordered. Next slide, Kathy. So the general counsel in her memorandum offers employers 60 days to cure pre-existing unlawful stay or pay provisions. So that would be until December 6, 2024. And while she provides this opportunity, I just want to note again that the general counsel memorandum is not binding, but it could be used as guidance by the NLRB. And given that she provides the 60-day period, we're not able to analyze whether these regional offices or directors will, in fact, use this guidance as a basis for finding violations of the NLRA. So, as with most things, I recommend consulting with legal counsel to assess the risks of implementing or enforcing non-competes and/or stay or pay provisions. All industries are different, all agreements are different, and I think it's just best to discuss that with the legal counsel on a case-by-case and specific basis. So that's my overview of the general counsel memo, and I will turn it back over to Gabe.
Thank you so much, Natalie. We appreciate your presentation. And there are a couple questions that came in through the chat. If you have an opportunity to attend to those, I'm sure those who pose the questions would be grateful. And clearly this is an area that we'll be tracking. There was another question that came in the chat concerning, so what does the election mean for all of this? There are elections, plural, happening next week. And I think it is difficult for us to say at this point, which is what I responded to the person who was posing it. And I'm sure it's applicable here. If the federal administration changes, that may or may not have an effect on this memo. We'll all have to see. But thank you for providing us with the update. That's really very useful. And please come on back in a future instance. We're delighted that you could make this time. And so let me, with that, turn to the material that I'll be covering today. So I'm actually going to be tackling two separate matters that fall within the healthcare space. And so to the degree that's the area where I do a lot of my work as an attorney, I thought it made sense for me to take these on. And so first, what I'll be talking about is Section 504 of the Federal Rehabilitation Act, and then I'll be shifting over to hospital cybersecurity standards here in New York State. So Kathy, if you go to the next slide, please, I'll get things started. And this material, by the way, is also covered in an information memorandum, that I co-authored along with Mario Ayub, who's been on the show many, many times, as well as Roger Bearden similarly. And so I'm speaking on our collective behalf around this material. So if you could go to the next slide, please, Kathy, I will get started. So Section 504, and it's really important to recognize this. It's a new rule that became 504 is not a new rule, but modifying elements became active on July 8th of 2024, a few months ago, modifying Section 504 of the Rehabilitation Act. And just for everyone's reminder, what is 504? Some of you may be familiar with it, some of you may not, but it prohibits entities that receive federal financial assistance, and I'm reading from the slide here just because the language matters, from discriminating against disabled individuals in areas including opportunities to participate in or benefit from federally funded programs and in employment opportunities. And it goes on. So you may be thinking, why does this matter? It doesn't apply to me. In fact, in many instances, it does, because those subject to 504 include hospitals, healthcare providers, public schools, higher education institutions, certain nonprofit organizations, depending on their configuration. And these are just some examples. As Natalie indicated at the last moment, if you have questions about whether you fall in or fall out, please check in with an attorney you trust. But we just wanted to make sure you knew about this because it affects many different industries, and it's worth taking a moment to walk through. So if Kathy would go to the next slide, I will do just that. So covered entities, which is really what 504 defines as covered entities. Let's be clear on that. It's not what HIPAA or some other regimes turn to when they think of covered, or rather when you think of a covered entity. So this is specific to 504. Let me be clear about that. They're prohibited from denying or limiting treatment due to biases or stereotypes arising from a person's disability. This is really what's new. A stereotype or a person's disability. Now, let's think about what that looks like in real time. HHS has opined, put out some information memoranda on this, or a memorandum, I should say. Think about someone who is awaiting a heart transplant and on clinical metrics is appropriate for it, but the healthcare provider says, well, you know what, maybe not, because that person lives with autism and there's a question around whether that person could feasibly manage postoperative care. That's impermissible under this refinement. Think about another scenario, someone who is living with Alzheimer's disease and that person does not receive ventilator assistance because the provider believes that the individual won't be able to manage that in the context of the cognitive decline that often comes with Alzheimer's. These are now, under the law, impermissible. So let's go to the next slide, please, because I think all of you can think about any number of scenarios that might apply in your workplaces. And so there are some obligations that attend to this. And so those who have self-service kiosks should ensure that their kiosks are accessible to individuals with disabilities, or you need to have alternatives. We know that in our increasingly tech-oriented interfaces for customers and others, it often is facilitating to use kiosks and things of that nature, but under this law and the adjustments to it that I'm articulating, and again, that go back to July, you have to pay attention to how you are making information available. And so that's one area that's touched by this. And then if you look at one of the forward-facing elements that isn't in effect today, but will be on May 11th of 2026, covered entities with 15 or more employees must ensure that all web and app content complies with heightened technical standards around accessibility. I don't know who's familiar with the WCAG guidelines, but that's essentially what's at play here. There's more that you can read about in the standards themselves, but for those of you who may be unfamiliar with those standards, it's time to learn and get a little bit smarter on them, as it were. And May 11th, 2026 up. So this would be the time to start thinking about it. Next slide, please. So some ways to think about how do you come into compliance now. First, you want to designate an individual to serve as your organization's Section 504 compliance coordinator, if you haven't already. This could be an individual who holds other responsibilities, certainly, but you want someone, as it were, to own this material and be responsible for its implementation. You want to also think about creating formal grievance processes so that someone who feels that access has been somehow denied or otherwise infringed upon has a means of elevating that information for your analysis and review. It's a way to get ahead of issues before they get bigger. You certainly want to assess your current non-discrimination policies and determine the updates that you think are appropriate based on these new standards. And again, with that May of 2026 deadline for your online presence, you want to be looking at your web pages and the like, getting that improved upon if all of that material needs to be tightened up. So I know that it was probably a lot to absorb if this is new for you, but again, we have a more detailed information memo that we issued on this topic. And of course, any attorney with whom you feel comfortable asking questions, if you have them following this presentation, please reach out because, we here at Bond certainly want to be helpful if you want to think about how this all applies to your organization. So Kathy, why don't we go to the next slide, please, which if you could advance one more, I will touch upon this material. And I'm not going to go too deep here, but just be aware, particularly for hospitals, and that means those that deliver acute care in sort of the traditional sense of what one thinks of with a hospital. That's what we're talking about here. For those of you who are perhaps a little deeper in these weeds, we're not talking about nursing homes, which in Article 28 can be also thought of as hospitals, using some of the older terms of art. Here we're just talking about what is more conventionally thought of as a hospital. And so notice of adoption was issued by the state's Department of Health through the the New York State Register, excuse me, on October 2nd of 2024. And essentially what that means is that we now have a new section 405.46 of Title 10. Title 10 is where most of the health regulations in New York State reside. There's some in a few other places, but many of them at the very least are found in 10. So it's a logical place to include this. And essentially, the headline is that hospitals must have a cybersecurity program. Many already do, so this isn't starting from scratch, but the point of the standard is that everyone must. And so compliance is not today. It is about a year from now, October 2nd of 2025, for most elements within this. The catch, however, is that there also was language that made clear that if there are issues that arise and meet the standard of a cyber incident as defined in this reg, I didn't go through the details of how that's defined. It's all in the reg, and certainly, an attorney can help you with that. But if it happens within, your ambit, the Department of Health is looking for you to give them notice within 72 hours. That piece of this regulatory schema is immediately binding. And for those of you in these weeds already, you may be wondering, so how does it relate to my federal requirements? I already have the SHIELD Act here in New York State. None of this is intended to supersede or otherwise stand in the place of. It's additive. So the Department of Health wants to be notified about all of these types of activities, again, as defined within the reg. So those listening may be wondering, well, how do I make sure that notice follows through in a way that the department recognizes? What are the procedures? What does the operational pathway look like? That's all still being defined, and the department is going to be issuing further guidance on that. But just know that as of October, the Department of Health has the expectation by way of regulation that it can be notified. So that is really, the thing that I wanted to make sure all of you are familiar with regard to the cybersecurity standard. We will certainly be tracking this and other regs as they relate to healthcare and data privacy. So look for more content on future Tuesday webinars on this and related topics. And with that, let's turn to our next presenter for the afternoon, because I think that I'm done with my content here. So Kathy, if you wouldn't mind advancing to the next slide, that would be great. And Alyssa is going to be covering the FTC guidance that I mentioned during the comments at the top of this program on, I guess, what now is the FTC beat that Alyssa has adopted. She has been on the program more than once. And if memory serves, you talked about FTC in a previous presentation. So Alyssa, we're delighted to have you back. And as a reminder to our audience, Alyssa sits in our Syracuse office, and Alyssa has been very focused on giving us material that is relevant to the wide array of practitioners that we have tuning into this program. So I'm really glad that, Alyssa, you've made the time to be back with us, and the floor is yours. Thank you.
Thank you, Gabe. Hello, everyone. I'm happy to be back to discuss another new FTC rule. This one is being dubbed the click to cancel rule, but it's a little broader. It actually covers recurring subscriptions and negative option programs just generally. So let's start on the next slide with what is a negative option plan. A negative option plan is really just a fancy term for things we're very familiar with, which is recurring subscriptions. The definition is really when a consumer's inaction is what is actually enrolling them in the subscription of some type. They usually fall into one of 4 categories. The first being a pre-notification plan. This is when a seller notifies the consumer that they're going to send them goods, and unless you return the goods, you will be charged for them. This was originally covered in the FTC's original negative option rule in 1973. And this new rule is expanding into the types of plans that we are seeing more often today. So that would include continuity plans. That's when a consumer agrees to receive periodic delivery of certain things, and until they cancel that periodic delivery, they're going to continue to be charged for and receive those goods. Additionally, automatic renewals. This would be something that really doesn't expire until the consumer takes the affirmative action to cancel it. And then lastly, the one that is most likely to get me is a free trial conversion offer. And that's when, I'm enticed with a free or low cost option for a limited time, give my credit card information, and the company is hoping that I either like the product so much that I stick with it, get charged the full price, or what has really given rise to the FTC taking action, the seller has made it so difficult to cancel the free trial that I end up just paying for the subscription. And so, to be clear, these 4 types of negative option plans are not being banned by this new rule. What the FTC is doing is setting some parameters on how these plans need to be rolled out and to protect consumers. So let's talk about what it actually does. Can we go to the next slide, please? As you know, the Federal Trade Commission's goal is to protect consumers and promote fair trade. With the Federal Trade Commission receiving almost 70 complaints a day regarding subscription plans and hard to cancel plans, they have taken the action to codify their expectations and modernize how the law is reacting to a subscription economy. And to do that, they are implementing this click to cancel rule, which is also mirror cancellation. The key takeaway would be that cancellation must be as easy as enrollment. If your customer was able to, immediately enroll online, they need to be able to cancel online. And that's where the mirror cancellation comes in. However they enrolled needs to also be offered as a cancellation mechanism. We've seen situations where a consumer can sign up in an app, but in order to cancel, they have to go online or make a phone call, mail a letter. Those are the activities that the FTC is taking action against. If a seller allows enrollment in person, the FTC is now requiring that cancellation is allowed over the phone. This is because the FTC doesn't want someone who moved, across the country to have to go back to their old local gym just to cancel. And so the processes for cancellation need to be as easy as enrollment, and also be easy and transparent of how to get to them. And then additionally, if you are canceling over the phone, it needs to be immediate. There were situations that the FTC wants to address where, I guess, someone would call to cancel, but because the cancellation manager wasn't in, the cancellation wouldn't take effect for a good amount of time. So cancellation needs to be immediate. Now, the second part of this rule is, we'll talk about on the next slide, prohibits misrepresentation when selling through negative option rules. So there's disclosures and consents that need to be attained. When selling through a negative option plan, the fact that it's a negative option, the date and frequency that the consumer will be charged, and how to cancel all need to be clearly disclosed. And then the FTC is taking this a step further by requiring the consumer give unambiguous affirmative consent. And this is definitely a higher standard than what other consenting to in a transaction would look like. And additionally, this needs to be separate from any other consent to the transaction. So the customer needs to approve that it's going to be, you know, a recurring charge or standalone consent, which is the standalone consent, and then also consent to the other terms and conditions that are going along with the subscription or service that they are signing up for. Additionally, the rule requires that the consent, a record of the consent, be kept for at least 3 years. Let's go to the next slide, please. As I mentioned, this rule broadens and modernizes the FTC's efforts to combat unfair practices regarding negative option plans. And it's going to be codified in 16 CFR Part 425. Now, it's worth noting that there is some litigation regarding the validity of this rule. As always, we will monitor that and give you any updates if it's going to impact the rollout of these new provisions. But for now, we should assume and prepare for as if it's here to stay. So the standalone consent requirement that I just discussed will take effect 180 days after the publication of this rule, whereas the misrepresentation prohibition will take effect 60 days after the publication. That being said, if you have any type of auto payments, subscriptions, or membership plans in your business model, now is the time to review these practices. Let's move to the next slide to discuss what you can be doing now. As I mentioned, there are very specific rules about the disclosures and how to advertise the negative option plans. These disclosures need to be clear and conspicuous, and what that means is clearly defined in the rule. This means you need to be evaluating your user sign-up processes, because as I mentioned, how a user signs up is also needs to mirror how they can cancel. And so businesses need to evaluate those processes as well as looking at the cancellation experience. It is important to review these processes from multiple platforms. So you want to look at what does cancellation look like on a phone, on a desktop computer versus an app, and also be training your customer service teams to make sure that they have the policies in place to promote easy cancellation. As always, when you make changes to cancellation experiences, you're going to need to make sure that those changes are reflected in your general policies of your refund policies and such. So if this rule impacts you, you may want to reach out and discuss the disclosure language. As I mentioned, it needs to have some specific guidelines from the rule, and make sure that you're presenting the negative option plan in compliance with this. Thank you.
Melissa, we thank you. Very useful information, particularly for those who are in the context of businesses where these rules might apply and what you need to do vis-a-vis the customers. There's some questions that have come in the chat, Alyssa, so if you're able to take a look at those as well, that would be much appreciated. And now, in the last leg of our program for today, let's introduce Paige Rosenman. Paige is new to our program. We are delighted to have her. She's with us from Bond's Buffalo office, where I understand today it's raining. Here in New York City, it is not. But I hope that despite the raindrops, things are shiny again for Halloween for all the kiddos in the area. And what Paige is here to talk about today is essentially, what to do with GPSs as an employer in unionized and non-unionized settings. But before I turn the floor over to Paige, and I'm grateful again that she's here to present, all of you should get to know Paige just a little bit better. She did most of her study at State University at SUNY Buffalo specifically, where she was both an undergrad and as well got her JD, and her MBA, and she's someone who focuses on management side labor and employment. And she has also worked in healthcare at the previous stop before coming to Bond. We're delighted to have Paige on the program to provide perspective on this GPS technology, which is all the more present in our day-to-day lives and has interesting implications for employers. So Paige, welcome to the program. We hope this is the first among many future times you'll join us, and we're delighted to hear what you have to teach us.
All right, thank you, Gabe. All right, so as Gabe mentioned, I'll be talking about the use of GPS tracking in company-owned properties. So things like company vehicles or company-issued cell phones, those are kind of the most prominent items. So both of those situations, there's different considerations depending on whether it's a unionized or a non-unionized workforce. So we'll first start with the unionized environment. So it's important to first determine whether the implementation of GPS technology is a mandatory subject of bargaining. And just kind of give some background on what that means. The Supreme Court has held that matters that are plainly germane to the working environment and not among those managerial decisions that lie at the center of entrepreneurial control are mandatory subjects of bargaining. So I'm going to first kind of start and take a little bit of a detour into surveillance cameras, which is really instructive to this analysis of GPS tracking devices. So the National Labor Relations Board has issued decisions dealing with surveillance cameras, and they've held that the installation and use of hidden video surveillance is germane to the working environment and outside the scope of managerial decisions lying at the core of entrepreneurial control. So essentially, that means it has the potential to affect the continued employment of employees whose actions are being monitored. And as a result of that, use of hidden cameras is a mandatory subject of bargaining. So beyond hidden cameras, there's also cameras that we see in plain view on company property. And the board has held that those are also mandatory subjects of bargaining. So the board's clarified that the same rules apply for surveillance cameras, which are in plain view as they are in hidden, I almost said hidden view, but then they don't view. So when they're hidden or versus in plain view, they apply the same analysis. They're both mandatory subjects of bargaining. The unilateral installation of the visible surveillance cameras without providing the union the opportunity to bargain over that installation is a violation of National Labor Relations Act Section 885, which prohibits employers from engaging in unfair labor practices such as to bargain. So both the courts and the board have provided some guidance on issues related to surveillance cameras, in particular that the bargaining issues themselves, since they're mandatory subjects, must include the circumstances under which the cameras will be activated, the general areas in where they'll be placed, and how they'll affect employees if they're disciplined for improper conduct that's being done on those cameras. So taking all that into consideration, while the board hasn't explicitly addressed the bargaining obligations for GPS technology, there have been several advice memorandums issued by the Office of General Counsel that kind of talks about everything that I just discussed related to the surveillance cameras. So they've considered the installation of GPS devices as mandatory subject to bargaining under that same rationale of surveillance cameras. So for example, the Office of General Counsel found that the installation of GPS technology, which collected and recorded data relating to the location, the movement, the operation of a company vehicle, constitutes a mandatory subject of bargaining. The Office of General Counsel also reasoned that the GPS tracking system was an investigatory technique for monitoring employee misconduct, which is similar to other systems like surveillance cameras that have been deemed mandatory subjects. They've also found that the installation and use of a GPS device to track an employee suspected of stealing time is a mandatory subject of bargaining. So to the extent that you have things like company-owned vehicles or company-issued cell phones that are provided to employees of a bargaining unit, it's considered a mandatory subject of bargaining. So once we've reached that step and we've determined that the term of employment is a mandatory subject, the second level of the analysis is whether the parties have negotiated some sort of resolution in their collective bargaining. So we would want to review that CBA and assess whether it gives the employer the right to act in installing those GPS devices without going into that topic. So aside from the unionized environment, there's a different analysis for a non-unionized workplace, which is much simpler. The employer can implement that GPS tracking on company-owned vehicles and cell phones, and in those instances, you're simply required to follow New York's employee monitoring law, which became effective May 7th, 2022. And I know we've talked about it here on this presentation around the time that it became effective, and we have a blog post as well with more information. But essentially, this law requires that employers provide written notice to employees about electronic monitoring, which includes GPS tracking technology. So it's important to note that the law specifically requires written notice, and that written notice must provide specific language as required by the law, and it has to be given upon hiring and must be acknowledged by the employee in writing or electronic. The employer is also required to post the notice of electronic monitoring in a conspicuous place. Generally, it's recommended that this notice is posted with the other required labels. And that's all I have for you today on the GPS tracking tab.
Well, Paige, thank you very much. That was a great overview, really informative. There are many factors that employers should be thinking about, both in union and in non-unionized settings. So we're glad that you took the time to walk through the topic, but we are really glad that you made the time to be on the program. And as I mentioned before you began your remarks, please don't make this the last time. We would love to have you back. So if Kathy, you could go to the next slide, please, and as well, Paige, if I could just direct you to try to answer the questions in the chat as you can, that would be terrific. This is a note to the audience. If we don't get to all of your questions that you've posed, we will follow up, as is our practice. We'll make sure that you have a way to hear back from us. So if it's not right now, Paige can't type quickly enough, or anyone else has a question they posed on a previous presentation, trust we will circle back. I will be back with you when we flip the calendar to November. Of course, the next time that all of us will be together will be as we move to the middle of the month. The next broadcast is on November 5th. That is, of course, Election Day. And so we are not going to have breaking news, as it were, and results. That is not what this program is for. But certainly what we will be tracking very closely, as I alluded to earlier, is what are the implications of the various elections once we know who's won where, and how it affects various modalities of leadership, because all of that certainly will be relevant to a lot of the policies that we discuss, and who's writing and enforcing them, et cetera. So stand by for more on that as we move deeper into this calendar year. But on Election Day itself, you'll be with Kristen Smith, and look forward to a traditional program at that point. If you want to contact any of today's presenters, you have their contact information here. And so please take full advantage of it. And please remember that if there are resources that you're looking for, particularly around sexual harassment, and prevention, we have training materials, we have the New York Employment Law Essential Guide, which we always want to make sure that you're aware of. It's really a wonderful treatise. And if you have questions for any of us as attorneys, do reach out. We're here to help. In the meanwhile, wishing you all a terrific close to October, and we look forward to being back with you soon. Thank you for your continuing trust in our program, and in us as attorneys. We look forward to seeing you soon.